I like Johnny Five-O. His humor is growing on me, kind of like a tumor. And I find his audits to be fun. I mean, like, this whole bit, am I detained? Am I detained? But he sticks around because he wants that drama to last. I enjoy it. It makes me chuckle. I did not appreciate him recording the license plates and threatening to continue to do so until this guy, who's not a police officer, manages to call off the police. I it seems a little unreasonable to me, but whatever. But my issue with this one is he cites Gonzalez v. Castle Rock. And he says that in Gonzalez v. Castle Rock, the Supreme Court held that the police have no duty to protect you. And he makes a few big mistakes. First of all, if you're going to cite a case, it's Castle Rock v. Gonzalez, not Gonzalez v. Castle Rock. Beyond citing it correctly, it would be swell if you actually read and understood the decision. So I'm going to walk you through this one so that we are all on the same page as to how to appropriately understand Castle Rock v. Gonzalez. And we're going to start with South v. Maryland, which is a Supreme Court case from forever ago, 1855. This is where the duty to all, duty to none doctrine crystallized. In this one, a sheriff witnessed somebody getting kidnapped and did nothing to do it. And that's terrible, and I agree. The holding in it was it is an undisputed principle of the common law that for a breach of public duty to an officer, is an undisputed principle of the common law for a breach of a public duty an officer is punishable by indictment. But where he acts ministerially and is bound to render certain services to individuals for a compensation in fees or salary, he is liable for acts of misfeasance or nonfeasance to the party who is injured by them. To understand that sentence, you need to understand what sheriffs do. They have two basic functions. First function is officers, peace officers. They go out and they arrest criminals and they keep the peace. The second thing they do is they execute private judgments. If you win a lawsuit against somebody and the court awards you monetary damages, you can get a writ of execution and send it off to the sheriff to have them garnish someone's wages or levy a bank account or put a lien on real property, something along those lines. There are all sorts of things that the sheriff can do, and they charge you for it. So the sheriff, at least in the past, and it may vary from state to state, I don't know, don't really care, but in the past, at this time anyway, this particular sheriff had a bond. And the guy who was kidnapped wanted to sue the sheriff on his bond to get the money. A bond is money. It's a cash bond. So if he sues the sheriff and he wins, bada boom, bada bing, he gets money to compensate him for being kidnapped. But what the court said is that when he has a public duty as an officer, he's punishable by indictment, not by suit. So if he breaches his duty to the public, he can be charged. He can be incarcerated. He could be whatever. He could be prosecuted. The powers and duties of conservator of the peace exercised by the sheriff are not strictly judicial, but he may be said to act as the chief magistrate of his county, wielding the executive power for the preservation of the public peace. It is a public duty for neglect of which he is amenable to the public and punishable by indictment only. The prosecution acts in the name of the public. It's the state the state as a whole. It's the public as a whole. It's duty to all and duty to none, meaning no individual. So the sheriff has the job of keeping the public peace, not protecting the individual's peace. Now, if you want to sue the state or some entity organ of the state, like a sheriff or a Department of Social Services or a city, then you need a cause of action. States and the federal government have sovereignty. You can't sue them unless the state or the federal government has granted you a cause of action. I know the sovereign citizens are pulling their hair out at that right now. I can't sue anybody I want to. No, unfortunately, if they're sovereign, if it's the state or the federal government, then the state can grant you the power to sue the state. The federal government can grant you the power to sue the state or the federal government. But they give you a very specific thing that you can sue for by and under. So the one that everybody wants is 42 USC 1983. I'm sure you've heard of it. But in order to have a cause of action under 42 USC 1983, the state has to deprive you of any rights, privileges, or immunities secured by the Constitution of the United States or the laws of the United States. So you have to tie it in somehow that you have been deprived of some sort of constitutional right. The laws of the federal laws don't particularly pertain to the police. It would be very hard to get a suit against a police officer for violating a federal law. It would be harder anyway. Normally you do it under the 14th Amendment, violation of due process. So the 14th Amendment, so like if you get beaten, if they use unreasonable force in arresting you, it's the 4th Amendment via the 14th. If the state puts you in prison and they waterboard you, then that would be the 8th Amendment via the 14th. If the federal government does those, you don't have to worry about the 14th Amendment. So this is how they get in. So they have to tie it somehow for their lawsuit. They have to tie it in to a deprivation of rights under the Constitution. So this is where we're going to start. This is DeShaney v. Winnebago City Department of Social Services. It's a terrible case. Both these cases are going to be terrible. So, and by terrible, I mean heartbreaking. In this case, a father got custody of his son, not the mother, and he beat the boy, like beat the boy. And when the boy was about 4 years old, the father beat him so severely that he caused permanent brain damage, and he essentially made the child into a vegetable. So for the rest of that poor boy's life, he is going to be in a mental institution because he's unable to care for himself. And the petitioner, which is the boy who was injured, and his mother, wanted to sue the Department of Social Services under 42 USC 1983 because the Department of Social Services had cause to believe that the boy was being beaten, and they had opened an investigation of it, but they hadn't taken the boy away from the father yet. And I understand why they're doing it, and I'm not faulting them for wanting to do it. You know, if the boy had money, then he could get better care. So what the court held, the due process clause of the 14th Amendment provides that no state, so she's suing under substantive due process. Substantive due process is there are rights that are protected by the Constitution that aren't enumerated in the Constitution. It doesn't say anywhere in the Constitution that you get to marry the person that you want to marry. But there is a substantive due process right that's just kind of inherent in it that says you get to marry who you want to marry. The state can't tell you who you can or can't marry. That came up with the anti-miscegenation, the race mixing laws, where the states were trying to keep black people from marrying white people. And the Supreme Court held that there is a substantive due process right that allows people to marry who they want to marry. And people, you have a substantive due process right to live with your family. You have a substantive due process right to privacy. It's just these basic rights that aren't spelled out in the Constitution, but the Constitution kind of assumed them because nobody would have, at the time, suspected that there would have to be litigation on, can I marry the person that I'm in love with? So, the Due Process Clause of the 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. Petitioners contend that the state deprived Joshua of his liberty interest in freedom from unjustified intrusions on personal security by failing to provide him with adequate protection against his father's violence. The claim is one invoking the substantive rather than the procedural component of the Due Process Clause. Petitioners do not claim that the state denied Joshua protection without according him appropriate procedural safeguards, but that it was categorically obligated to protect him in these circumstances. Well, did that work out? It did not. But the claim here is based on the Due Process Clause of the 14th Amendment, which, as we have said many times, does not transform every tort committed by a state actor into a constitutional violation. A state may, through its courts and legislatures, impose such affirmative duties of care and protection upon its agents as it wishes, but not all common law duties owed by the government actors were constitutionalized by the 14th Amendment. Because, as explained above, the state had no constitutional duty to protect Joshua against his father's violence, its failure to do so, although calamitous in hindsight, does not constitute a violation of the Due Process Clause. The court is not saying that the Department of Social Services didn't have a duty. They're just saying that duty was not based in the Constitution. There is no substantive due process right to be free from getting beaten by your father. So that's the important language there. There is no constitutional duty, which is a different thing entirely than saying there is no duty to protect. There's no constitutional duty to protect. There may be other duties, but they're not constitutional. Finally, we get to Castle Rock v. Gonzalez. This is, again, a Supreme Court case from 2005. This is what Johnny 5-0 was referencing. In this one, this is also another just horrible fact pattern. The parents got divorced. The mother got a restraining order against the father. The father kidnapped the daughters. He killed them, and then he committed suicide by cop by going into a police station with a firearm and starting to shoot at people. And then they killed him, and it's terrible. But the mother had a restraining order. Notice to law enforcement officials: you shall use every reasonable means to enforce this restraining order. You shall arrest, or if an arrest would be impractical under the circumstances, seek a warrant for the arrest of the restrained person when you have information amounting to probable cause that the restrained person has violated or attempted to violate any provision of this order, and the restrained person has been properly served with a copy of this order, or has received actual notice of the existence of this order. So she sues under a 1983 lawsuit. Now you're going to say to yourself, well, didn't they already hold there's no constitutional duty? Well, she's suing under a slightly different theory. Instead of saying that there was a substantive due process right to being protected by the police, she's saying that because she got this restraining order, she had a procedural due process right to protection by the police. Procedural process is a little bit different than substantive due process. It's actually a lot different. The procedural due process component is that you can't be deprived of a liberty interest. If you have a liberty interest, you can't be deprived of it without due process of law. So you can't be incarcerated or put in a mental institution without the appropriate hearing without the appropriate formalities being gone through. There are also life procedural due process rights to life. You can't be obviously executed without due process. You can't have your cojones removed. You can't be castrated without due process. And I think actually that's been ruled to be a Eighth Amendment violation, but you see where I'm coming from. And then there are property rights. You have a procedural due process property right in things like if you start receiving benefits under Social Security or something like that, the government can't take those away from you without some sort of a hearing. Like if they think that you're scamming the Medicare system, like you're claiming to have like a bad back or something, and they can't just take it away from you if they think you're faking it. They have to go through the steps. They have to have a hearing. They have to present evidence that says that, here we have a picture of you lifting weights. Obviously, you're capable of working, right? So her argument is that she has a property interest in this restraining order and that she was deprived of her property interest because they didn't appropriately step in and arrest him in a timely fashion. So what does the court say? We conclude, therefore, that respondent did not, for the purposes of the due process clause, have a property interest in police enforcement of the restraining order against her husband. It is accordingly unnecessary to address the Court of Appeal's determination that the town's custom or policy prevented the police from giving her due process when they deprived her of that alleged interest. In light of today's decision and that in DeShaney, which we just went over, the benefit that a third party may receive from having someone else arrested for a crime generally does not trigger protections under the Due Process Clause, neither in its procedural nor in its substantive manifestations. This result reflects our continuing reluctance to treat the 14th Amendment as a font of tort law. But it does not mean that states are powerless to provide victims with personally enforceable remedies. Although the framers of the 14th Amendment and the Civil Rights Act of 1871 did not create a system by which police departments are generally held financially accountable for crimes that better policing may have prevented, the people of Colorado are free to craft such a system under state law. So what the court has held is not that there is no duty of the police to protect, it's that there is no cause of action under the 14th Amendment to sue local police forces for failing to protect. There's a difference. There's a huge difference. Like, say, for example, you ask a Boy Scout what his duty is. And he'll say, "On my honor, I will do my best to do my duty to God and my country, to obey the Scout law, to help other people at all times, to keep myself physically strong, mentally awake, and morally straight." Can you sue the Boy Scout if he fails in one of those duties? No, you can't. Does that mean he doesn't have a duty? No, it doesn't. So it's a fairly minor correction, but I keep seeing people pull this one out, and I hope this addresses it correctly. I hope you understand it. Thanks for watching. Thank you, Johnny 50, for making entertaining videos. Even when you're wrong, at least you're fun.